All right, we've got a lot to get to today, so let's get started. So without further ado, introducing Stoneleigh Foundation's Deputy Director, Marie Williams. Marie, take it away.
Thank you, Mark. Good afternoon, everyone. As Mark said, my name is Marie Williams, and I'm the Deputy Director of the Stoneleigh Foundation. I'm pleased to welcome you to today's webinar, Finley No Merit Letters, the Erosion of Ethical Standards for Criminal Defense Lawyers. For those of you who don't know Stoneleigh, we're a Philadelphia-based foundation working to improve the life outcomes of our community's young people by advancing change within, alongside, and outside of systems that serve them and their families. We award fellowships to exceptional leaders like Jennifer Merrigan, who enhance how systems work together, improve practice, shift narratives, and generate new knowledge through action-oriented research. I think today's event promises to be a very powerful one, and my hope is that this conversation remains with you for a very long time. Over the last 4 years, we've supported the work of our Stoneleigh Fellow, Jennifer Merrigan, to partner with her colleagues at the public interest law firm Phillips Black and the Conviction Integrity Unit at the Philadelphia District Attorney's Office to improve the representation of young people, some of them not young anymore, who have been wrongfully convicted and sentenced. Today's conversation is an outgrowth of that work, and it's the culmination of a years-long effort to shed light on a part of our criminal justice system that for far too long has operated outside of proper public scrutiny. Over the next 90 minutes, you're going to have an opportunity to hear from 4 experts who are on the front lines of building a better post-conviction defense process, one that safeguards our constitutional rights and remedies the wrongs that have been inflicted upon individuals who are poor, a majority of whom are Black and brown, and incarcerated. But before we get to the substance, one quick note on logistics. We're going to leave ample time at the end of the webinar for audience questions. But if you'd like to submit a question at any time throughout the event, please do so by clicking the More button at the bottom of your screen and selecting Q&A. With that, I'd like to turn it over to today's speakers. They'll each introduce themselves more fully, but we're honored to have with us today Jennifer Merrigan, a Stoneleigh Fellow and the co-founder and principal attorney at Phillips Black, Stephen Lazar, a paralegal at Phillips Black who was exonerated in 2023, Yahya Moore, a paralegal at the Pennsylvania Innocence Project who was exonerated in 2023, and Thomas Roberts, a staff attorney at Phillips Black. Welcome, Jenny, Stephen, Yahya, and Thomas.
Thank you.
Thank you so much, Marie. I will just start off by saying that I do see that I wrote that Yahya Moore is with Phillips Black. Clearly, I would love to poach him from the Innocence Project, but he is not with Phillips Black. He's with the Innocence Project. So I want to clear that up on this opening slide here. And I'm going to go ahead and get us started. And the way this is going to go is that I'm going to start today's webinar by telling you all about a client of ours. And then we're going to talk a little bit about today's study, have a discussion. And then, like Marie said, we've got a lot of time for questions. And I think that usually there are a lot of questions around this. So we have a client who spent 28 years wrongfully in prison until he was released just a few years ago. Eric was 19 years old and the passenger in the back seat of a car when 2 of his friends went into a store and robbed it. In the chaos of the robbery, one of them shot and killed the store clerk. Now, this is a tragedy to be sure, and you might think that an investigation or a trial would be held to determine what each of the friends knew or what their participation was, or even what their intent was. What did they intend that day? But that is not how the law works. In Pennsylvania, you are guilty of second-degree murder if someone is killed during the commission of a felony and you participate in that felony. So everybody involved in the felony, no matter what they actually did or what their intent was, even if they were just in the car, is guilty of felony murder. The Commonwealth of Pennsylvania charged Eric and 3 of his friends with this murder, and they all went to trial. All 4 Black men, and all 4 were under the age of 20 at the time of the crime. Eric was convicted of second-degree felony murder, and up in Pennsylvania law, up until very recently, second-degree felony murder had a mandatory sentence of life without the possibility of parole. So after Eric was found guilty, he was immediately sentenced to life without parole, put on a bus, and sent upstate to the Department of Corrections. Eric's very first opportunity to appeal this decision was during the direct appeal process. This is a narrow procedure which is reserved for errors that are on the record. Usually this means that the judge or the prosecutor makes a mistake and the trial lawyer objects. That is known as preserving an error on the record. Or if there is a glaring constitutional error, which is just very clear from the record itself, from the transcript, the direct appeal lawyer can raise it at this stage. In Eric's case, his direct appeal lawyer saw such an error. It was a big constitutional error, and the lawyer briefed it and took it all the way up to the Pennsylvania Supreme Court. That court agreed to hear it, and then for very complicated, nuanced reasons, dismissed that at the last minute, and they didn't hear it. That should have been okay because Eric had one more appeal in the state court. This one is called the post-conviction review, and this is what we're going to be talking about today. This appeal is arguably your most important appeal. It is your first and often only chance to show all of the mistakes that your trial lawyer made and all of the things that they should have done. For example, if your attorney failed to call your alibi witness, failed to object to racist arguments or unethical arguments from the prosecutor, failed to object to inconsistent testimony, testimony that a witness contradicts themselves, or fails to obtain important records. These are all examples of the kinds of claims that you would bring in post-conviction review. Post-conviction review is the opportunity to take a good look at your trial and make sure that your trial attorney measured up to the standards of the Constitution. This is very important in Pennsylvania, especially in Philadelphia, if you are on trial for a homicide. And that's because the majority of people on trial for homicides in Philadelphia are represented by private court-appointed lawyers at trial instead of public defenders. Those court-appointed lawyers receive some of the lowest fees in the country. The maximum allowable payment to prepare for the trial is $10,000. That may seem like a lot of money, but that has to pay for all of their time preparing, all of their time investigating, reading the evidence, preparing the witnesses, and meeting with their client. That is hours and months that they spend getting ready for trial. And just by comparison, Montgomery County, which is, just our neighbor to the north, a lawyer gets paid up to $50,000 for a homicide trial. In Eric's case, his court-appointed lawyer missed a crucial constitutional issue. And so as a result, his court-appointed post-conviction attorney should have and could have brought that to the court's attention in the appeal. But he didn't. He filed what's called a Finley no merits letter. In Pennsylvania, lawyers appointed in post-conviction can either file a petition telling the court all of the things that your lawyer should have done, or they can file a Finley no merits letter. Under a case called Commonwealth versus Finley, if your lawyer reviews your court record, looks into anything you've requested, and then finds that you do not have legal issues, they can issue this no merits letter to the court and withdraw from your case. In theory, perhaps that makes sense. What if you had the perfect trial and your lawyer did everything that they could do? Well, in order for your post-conviction attorney to determine that you don't have any legal issues, they would have to undertake an extensive investigation and fully review all of the facets of your case. In Eric's case, his post-conviction lawyer never did any of those things. He never met with Eric. He never even spoke with Eric. And we know that he never read the court papers in the case. Had he read the one and only appeal in the case, he would have discovered this very serious constitutional violation, and he would have told the court about it. Instead, he told the court, there's nothing to see here. There is plenty of evidence against my client. And he even took a few minutes in the letter to make fun of Eric and belittle him. The Finley no merits letter was the first and only letter that Eric ever received from his post-conviction lawyer. He was 21 years old when he got it in the mail. He was in prison very far away from home, and he did not understand the severe consequences of the Finley letter. What happened next is that Eric's case got the attention of the Stanford Law School Legal Clinic. This is a prestigious clinic. They only take a few cases per year. And they took his case because this constitutional violation was so grave and egregious. The students and the professor took his case all the way up to the United States Supreme Court. And despite the clear violation here, the Supreme Court denied the petition and ruled that Eric's lawyer could have and should have raised the claim in post-conviction. And because he didn't, Eric could never raise that violation again, and he had to stay in prison, even though this should have mandated his release from prison. That is because the Supreme Court views the lawyer as the agent of the client, and the lawyer's mistakes are the client's mistakes, even when the lawyer has never met the client, has never spoken with the client, and has never even read the most basic court files in the client's case. So Eric's post-conviction's lawyer's failure to read the basic document and raise this important issue meant that Eric lost this claim forever. And the Supreme Court wrote that it was, quote, it was a predicament of Eric's own creation. Today, Eric is finally out of prison because of the Philadelphia Conviction Integrity Unit. My office, with the support of Stoneleigh and other organizations, have been able to represent people who are wrongfully convicted, many of whom, like Eric, were young people when they were sentenced to die in prison. In Eric's case, once the DA shared his file, the police and prosecutors' file, we found evidence that proved that the prosecution's key witness was lying, and that the police and the prosecutors in the trial knew it. Eric was returned home to his family, his mother, his children, his grandchildren, after decades in prison. These are decades that were lost in large part because of the Finley letter that his own lawyer filed in this case. We were really shocked by this. We were really shocked to see that this is how the system was working in Philadelphia, and we decided that we should conduct a study of Finley letters to determine if there were other cases like Eric's, where an attorney failed to take even the most basic mandated steps before informing the court that their client had no legal issues. And the short story is, which is about to be a longer story because that's what we're going to talk about for the next hour, there were many, many other cases like Eric's, many others. So, and honestly, it was worse than we had even imagined when we started out. And I'm going to turn it over now to Thomas and Yahya to discuss some of these findings.
Thanks, Jenny, for starting us off with that narrative. I think it's important to start talking about this study by recognizing that this study came about as the result of listening to people's experiences with the criminal legal system, listening to people's experiences like Eric's and other people's as Yahya is going to share about his own experience going through this. And the point of this research is to amplify those experiences and demonstrate that these are happening not just to one person, not just to two people, but that these are system-wide issues. So a couple framing things that we found in our study, and then I'll talk about a little bit of the details of what Finley is and what exactly our study looked like. But I think it's important to highlight from the very outset that there are two things that were true about our data set. This procedure, this Finley no merit letter procedure, which, as Jenny outlined a minute ago, is essentially a withdrawal procedure. It's a way for a lawyer who's appointed to a case to get off of the case. And we found that it was associated with a high degree of unethical lawyering in a lot of different ways, and we're going to get into that. But this is a procedure that is reserved mostly for people who are Black. So we found a dramatic overrepresentation of petitioners who were Black, who were being appointed, court-appointed lawyers who then were withdrawing via the Finley procedure. And 100% of the people who are receiving the level of process that the Finley process affords are poor. Every single letter that we reviewed came from an attorney who had been appointed to the case, not retained. So in every single case, this was a person who could not afford counsel, and they had been appointed a lawyer. And so this breakdown in legal ethics that we're going to talk about today is reserved exclusively for people who are poor and predominantly for people who are Black. So taking a step back, Finley is essentially a way of making it easier for lawyers to withdraw in certain cases. Finley, it's important to distinguish Finley from what happens in the federal context, where when the Sixth Amendment applies, the federal Constitution, the Sixth Amendment, there is a different procedure for withdrawal, and we're going to get into kind of the nitty-gritty of that in our sort of panel discussion. But suffice it to say at this point that essentially if a lawyer had to comply with the dictates of the Sixth Amendment, then there would be a more difficult withdrawal procedure. And in the case Pennsylvania versus Finley, what the courts decided to do was they were going to say, okay, if a lawyer wants to withdraw from a case in post-conviction proceedings, then we're going to make that easier. They do that because the Supreme Court of the United States decided that in the case called Pennsylvania versus Finley, the Supreme Court of the United States said, the Sixth Amendment doesn't have anything to say about state post-conviction procedures. And because it doesn't have anything to say, states are kind of free to do whatever they want with respect to, there's probably a floor at some point under other constitutional considerations. But, we're going to give states a lot of leeway in designing how they're going to handle state post-conviction proceedings. And what the courts in Pennsylvania did on remand in that case is they decided, and let's be clear, the courts in Pennsylvania could have decided we're going to actually have higher standards for our lawyers in Pennsylvania. Instead, what happened was the courts made it easier to withdraw through the Finley letter procedure. And it's really important how they decided to do that, because one important distinction that Jenny touched on in her intro that is key to understanding what's at play here is, most people in our culture understand that people who are charged with a crime who can't afford a lawyer are given a lawyer, right? That has permeated popular culture, that has permeated our legal culture. It's something that a lot of people understand. And it's important to understand that, it's one thing to say that there is a right, and it's another for lawyers and judges and legislators to design how that right, when it's violated, is going to be remedied. And so in Pennsylvania, if you're afforded a lawyer who does a bad job, like Eric's, like Eric's counsel did, then actually under the laws in Pennsylvania, you can't raise that issue until you get to the post-conviction stage. So you can't raise it at trial. You can't raise it during your direct appeal. You have to wait until this post-conviction process where the Sixth Amendment no longer applies. So now this is, the federal Constitution, according to the Supreme Court, is silent on this issue. It's a bit of a catch-22. Once the Sixth Amendment stops applying, that's when we're going to examine whether the Sixth Amendment has been complied with. And, It's really important to recognize that the types of things that lawyers should have done, that they didn't do, doesn't typically show up on the record and involves investigation. And even, in addition to investigation in terms of going and talking to witnesses in the case, talking to maybe a potential alibi witness who wasn't called, or someone's family member who has some insight into something that might have gone wrong at trial. The Supreme Court of Pennsylvania has been really clear that one of the things that post-conviction counsel needs to do is post-conviction counsel needs to communicate with their client. As a matter of fact, in a case called Commonwealth versus Grant in 2002, the Supreme Court of Pennsylvania said that post-conviction counsel has the burden to interview the client. And with that, I kind of want to pass it off to Yahya and have Yahya speak a little bit about his experience and what kind of communication he was getting from his post-conviction lawyer.
Well, thank you, Thomas. Well, first, the experience that I had goes all the way back from the first trial counsel, right? When you grow up in under-resourced communities, you learn that if you get in trouble, you need an attorney. And we know that because we know sometimes attorneys need attorneys, right? And so we put a lot of our hope in an attorney. And so I had a trial counsel, and he was appointed, and I never seen him. I never seen him. He never even wrote me any letters. And I go to trial with this attorney, and I lost trial. So after I lost trial, moving forward, I'm sitting in my cell. I'm trying to figure out what happened at my case, what happened. I'm thinking about, I need another lawyer, but of course I don't have any money. And so now comes the post-convictions phase. I get a letter from my PCRA counsel, and I'm thinking, okay, great. I got a letter. This is something great. And she asked me what kind of issues that I think I had. And so being as though I didn't have any notes of testimony, I didn't have any discovery, because when you get convicted, you don't get any of these things. You try to write your attorney to get them. A lot of times they don't even write you back. And so I'm in prison with none of these documents, but I'm still trying to formulate what kind of issues that I've had. And most of the time, and many people who go to trial, most of the trial is like a blur. The legal jargon, the terminologies, all of these different things is like you're being, circles are being ran around you. You don't understand any of it. And so you rely on your post-conviction attorney to actually structure a nice argument for you, depending to the courts. And so the first line of my Philly letter, my Philly attorney had gotten my arrest wrong. The date that I was arrested, she got it wrong. And I'm thinking to myself, if she could get my date wrong, I'm in trouble. And so, but I had to continue with her. And so I tried to smooth her. Hi, I'm trying to speak nice to her, try to wow her, try to do everything that I could to make her put some effort into this PCRA for me. It didn't work. It didn't work. Eventually, she did just as some of the statistics say in the report. She revealed some of confidential information to the judge. Didn't investigate some of the witnesses. A lot of things like this. And so I look up. The judge had sent me a letter telling me that my PCRA was going to get dismissed. So now, mind you, when I get the letter, it's already 12 days late. So essentially, the letter said you had 20 days. So now I only have 8 days to answer this. And I scramble. I scramble and I answer it, but my PCRA still had gotten dismissed. And so those are some of the difficulties that occur when a person who's incarcerated get a post-conviction counsel and they get a PCRA no merit letter. Of course, I did have merit in some of my issues because at least one of my issues, the Superior Court had wrote a dissent. And in this dissent, the judge had said that they would have given me a new trial, right? And so I try to use this dissent as persuasive argument going forward, but it didn't work. Yeah.
Yahya, I wondered, you mentioned that your Finley lawyer, wrote you a letter. Did she ever come and see you?
Well, she did not.
Did you ever have a telephone call with her?
I did not talk with her either. And in fact, one letter that I had wrote her, I sent it certified. So when I first got in prison, I learned from some of the older gentlemen who worked in the law library that you have to make a record of all of your correspondence. And so I sent a letter to my Finley counsel, my PCRA counsel, but she's the Finley filer in this instance. I sent a letter to her and I certified it. And that got her mad. She wrote me back telling me that she only accepts letters that are sent first class. Yeah.
Well, every time you say that, it makes me burn with rage. But you were trying to make a record, which is the law librarian you talk to is correct. That's what we always have to do in court. We always have to make a record. And for your attorney to fight you on that is just really upsetting.
Yes, it is. It upset me as well.
And I wonder, Thomas, that this next slide, I think, goes into what we found in the study about lawyers failing to communicate with their clients, which was Yahya's experience and was not unusual then.
Right. That was not an unusual experience based off of our review of these letters. One of the really sort of perverse dynamics that the Post-Conviction Review Act in Pennsylvania and Finley sets up is that the way and I think Yahya's experience really speaks to this powerfully. The way that you initiate this post-conviction proceeding in Pennsylvania is that it's on the petitioner to file a petition pro se. So people who are incarcerated, who are typically lay people who don't know about the law, have the opportunity maybe to go to the prison law library for an hour a week, typically do not have the records from their trial, the transcripts that were created, the different exhibits that were entered at trial, the different discovery that the state disclosed before trial. Typically, people are, like Yahya was describing, people are having to try to remember what happened at their trial. People are, I think, Yahya was describing using this dissent from a Superior Court case. There are people under extraordinary pressure who are incarcerated, who are having to learn how to be an attorney for themselves in short order. And then what happens is, okay, so the person files that petition and they're appointed a lawyer, and the court holds this person out as, your lawyer. And the lawyer is supposed to talk to their client about the claims that they have, is supposed to develop those claims. The person who wrote that petition, Yahya was the expert about his case. That's part of the frustrating thing about, learning about the degree to which lawyers aren't communicating with their clients is that clients are people who are incarcerated, who are trying to fight for their freedom, are an extraordinary resource for information about their case. And people, Finley puts lawyers in a position where instead of being duty bound to be an advocate for their client, they are actually more like a lawyer with an asterisk or a lawyer minus, because this lawyer can withdraw. And we see that capacity to be able to withdraw is impacting lawyers' behavior and how they approach the case in the first instance. So we have lawyers who aren't communicating with their clients. If Jenny, if you want to hop to the next slide, I think we have a great example of that. Just to demonstrate what kind of evidence we're talking about looking at these Finley letters. We say, this is from a Finley letter that says, talking about this specific contention concerns the quote extrajudicial, end quote, whatever that means, statement made by the petitioner. So if you think about that, this is in a Finley letter that an attorney is submitting to a court. And that quotation is coming from that lawyer's own client's pro se petition. And what the lawyer is doing here is creating distance between themselves and their client, right? They're saying, I don't know what my client is talking about. And they're doing this in a public document that's going to be a part of the record forever. And instead of, sort of mocking their client for not using the correct terminology, what this attorney could have done is written the client and asked what they meant, which would have been the bare minimum. Call the client, or God forbid, go to the prison in person and visit with the client. I say God forbid, not because that's not something that lawyers should be doing, but because it's not something that is happening in these cases. In a lot of different ways, we saw, and this is laid out in the report that we published, we saw a lot of instances of different ways in which lawyers are creating distance between themselves and their clients, which is noteworthy because, remember, the Supreme Court of the United States has said that these are agents of petitioners, right? And I'm glad we're hopping to this slide because I think this leads really, really well into this aspect of our data, which was really disturbing, which is that, one aspect of a lawyer being an agent of their client is that there's certain trust that they have. They have a duty of loyalty that they owe to their client. And as part of that, people are supposed to be able to converse candidly with their lawyers about things that are helpful, things that are neutral, things that are unhelpful, or things that the petitioner doesn't know whether it's helpful or not and wants the lawyer's help to be able to figure that out. And so when someone holds themselves out as a lawyer, and is appointed as a lawyer, they're bound by the attorney-client privilege and they're bound by the duty of confidentiality. And we found that a significant number of lawyers, I'll start by talking about privilege. Privileged information is basically information that goes between an attorney and their client during the course of the representation, sort of in furtherance of the representation is the language they use. So communications about the case are protected by the attorney-client privilege. It's a really important privilege because you want to be able to tell your lawyer things in confidence, right? And we found some really disturbing examples of lawyers who were getting information from their clients and then using that information against their clients. And we have a couple examples of that on the next slide. Here you can see that, in this initial example, you have a lawyer who wrote to their client, asked them a question, that client responds, and then instead of, trying to formulate the way that information can be presented to a court in a way that might help their client, what they're doing is these lawyers are acting more like kind of investigators for the court, and they're communicating that information to the court, which is an ethical violation, right? Because why would someone trust a lawyer who's actually not acting in their interest, but is acting as a kind of court investigator and is actually acting against their own interests in what they're filing with the court? We also found violations of something called the duty of confidentiality being really common. The duty of confidentiality is more broad than the attorney-client privilege, but it's the same kind of idea. The duty of confidentiality covers everything relating to the representation, and so that basically means that, well, to take a central example, lawyers who went out and spoke to people related to the case. And then maybe you go speak to a person related to the case and they say something that's not super helpful for your client. Someone who's an advocate is going to say, gee, that's not a helpful fact. What can I do to investigate the context of that fact in order to make it more palatable for my argument? Or do I, to what extent, whether and how do I need to disclose this to the court, and really acting as an advocate instead of turning around and disclosing that information to the court. We found that that was happening in about a third of the cases we reviewed. So we're talking about systematic breakdowns in core, really core ethical obligations that lawyers have in every single representation that they have. And so, what we found is that
I actually I'll take this opportunity while you're having a sip of water to jump in, because your case, I think, was an example of this, where so Yahya is innocent and his co-defendant admitted to other people who the actual perpetrator was. And Yahya provided his lawyer with evidence of that, and the lawyer didn't present it. And in post-conviction, Yahya said, you need to go talk to my co-defendant's sister because she can tell you. And so the lawyer called the co-defendant's sister, and the co-defendant's sister said, this is really tough for me. I don't want to be involved. And so the lawyer then revealed that in the letter and told the court she doesn't want to be involved. So that's totally irrelevant. I'll be honest with you. I've very rarely had a case and gone to talk to a witness and they're like, I can't wait to go to court. I hope it takes a long time. I hope I have to get up early and pay $100 for parking and spend a week in court. Nobody wants to go to court. So it was against Yahya's interest for her to reveal this. It was also a violation of confidentiality. That was information that she got in the representation that she then revealed to the court. She could have subpoenaed the witness. It was irrelevant. Every time I talk about this again, I become full of rage. I'm sorry. And so, Yahya, for you had asked her to speak to this witness, and then you get this letter against you, revealing that what you asked her to do, revealing what the witness said in a way that was harmful to you. And I guess, I wondered how that felt or what you thought about that when you got that.
Well, I always was angry about that because when we're talking about whether or not a counsel was ineffective for failing to investigate, interview, and call a witness, all the elements were there. The witness, the witness was existed. The witness had material evidence that was could have helped in the trial. The witness was ready and willing to testify. So all of these elements was there. And so when the post-conviction attorney called her, right, and she got this information, she should have, in fact, found an affidavit or found a subpoena to compel her to come to court. I mean, if this evidence was in fact going to free me, but I ended up spending another 20 years in jail. And this happened in 2004. Yeah. And so I ended up spending a whole lot of time in jail, still fighting. And that issue had went all the way up to I was granted a certificate of appealability on that particular issue. And then they were looking at it in light of Martinez versus Ryan, looking at which sheds light on the post PCRA counsel. But eventually I lost. Yeah.
Yeah, thank you for sharing that. I also feel very angry because that is just absolutely not what a lawyer should be doing. So Thomas, I skipped ahead to this one because we were talking about confidentiality, but I think we should go back and spend a minute talking about the duty of competence, which was also violated in your case, Yahya.
Yes, it was.
Yeah, and I think that I actually think there's a causal relationship between the breakdowns here, right? Because the whole idea of our system of justice is that it's adversarial, right? And you have an advocate and they're loyal to you and they're going to go in and they're going to be fighting for you. And and on the other side there's going to be the state, and the state is going to be arguing against you, and there's going to be there's going to be an adversary nature to that proceeding. And when that breaks down, that's kind of a check on people. If you know that someone's going to be trying to argue against you, it's going to make you be more careful in what kinds of legal arguments and what kind of factual assertions you make. And I think that you see this sort of concomitant breakdown in the duty of competence where the adversary system is broken down. We found a huge amount. At the end of the day, legal claims are kind of about two things. They're about facts and they're about law, right? Lawyers, there's different cases present different fact patterns, and there's different legal tests that we have to determine what the law is going to do about that fact pattern. And so, when you break down what lawyers are supposed to do, lawyers are really supposed to be engaging with the facts and the law. And what we found was a huge amount of deficient legal analysis in these letters. We found that there were attorneys who were, in some instances just getting the law wrong, not applying the right tests. In a lot of instances, the law is arguable and people argue about what is the applicable test and what the court should do. And in a lot of cases, we saw that lawyers, as opposed to acting as advocates for their client, were going so far as to, really acting as advocates against their client. The advocate had become the adversary, because what they were doing was, and I think the statistic is 84%. In 84% of the letters we found, we found that lawyers were actually, where there were two interpretations of the law, and one was helpful to the client and one was unhelpful to the client. The lawyer, the Finley filer, was taking the unhelpful interpretation the vast majority of the time. And so you have this, and we're going to talk about this a bit later, but the district attorney typically wasn't filing anything in this case. So that was kind of like the last word on that legal issue, was whatever that lawyer wrote, and was often a biased take of the law. I will skip facially unscrupulous legal analysis right now because I think we have a picture later in our there it is. The incompetent legal analysis slide here. We have, if this screenshot here, this C through H, which skips a letter I'm seeing, is this is a screenshot right from a Finley letter. This was the extent of the lawyer's assessment of these claims. So if you look at item D, you see previously litigated, C page Superior Court. So you can see that they've forgotten to include the page number that they perceived, the Superior Court opinion to be supporting that in. And in the law review article that Yahya and I wrote, we look at that Reagan citation and point out how it actually couldn't possibly stand for the kind of thing that they're saying it stands for. This is the level of analysis that that this lawyer saw fit in to submit in a Finley letter. The other side of this is the law, right? Or excuse me, the facts, right? So there's kind of two types of facts. There's facts of record, and then there's like extra record facts. All of those facts that lawyers in post-conviction are supposed to figure out by talking to the client, by talking to witnesses, family members. The language that the Supreme Court uses is very broad. The Pennsylvania Supreme Court says that they need to talk to anyone who might have information about claims that could be brought in the case. And, first we saw a huge amount of evidence that there were failures to engage with the record. This is like Yahya's lawyer getting the arrest date wrong. This is a fact that's on a piece of paper in the record, and competent lawyering requires that, significant dates in the history of the case, especially in procedurally complex cases like post-conviction cases, dates are super important. And here you have a complete, you have an attorney who's saying, Your Honor set forth in your opinion a comprehensive synopsis of the facts. Counsel sees no purpose in doing so herein. That's an astonishing just sort of abdication of the lawyer's role as an advocate, saying, what the court said, I just agree to it wholesale. I'm not going to try to add to it. I'm not going to try to nuance it or anything like that.
And just to add on to that point, that set of facts follows you the rest of your appeals. And so if your advocate doesn't challenge that, that follows you all the way to federal court. I think it's yeah.
Yeah, absolutely. That's such an important aspect of this is like, this is on the record forever, and as Eric's case demonstrates, it follows people.
And it's hard to undo.
Yeah, I just want to add one other thing about this slide, which is this last one. There's no indication anywhere in the record that the juror was asleep, through most of the trial, as the defendant has suggested. So, that defendant is, of course, this lawyer's client. The lawyer is writing this opposing what their client has said, which is that the juror was asleep through most of the trial. And I think that if you're not a post-conviction lawyer, this may not enrage you as much as it should, because you might not understand that the point of a post-conviction appeal is that it's not in the record. That's literally the whole thing. It's an extra record petition. So the lawyer's correct. There is no indication in the record. If there was, we wouldn't be dealing with it on post-conviction. What the lawyer would have had to have done is go out and conduct an investigation, talk to people who are at the trial, talk to their client, who is perhaps the indication that the juror was sleeping through the trial, because the client would have been looking at the jury, unlike the post-conviction lawyer who wasn't there. But this is the level to say to the court, like, can you believe this? There's nothing in the record that he was sleeping through the trial. Like, give me a break. No. So you're going to have to get an affidavit. You're going to have to interview the trial team. You're going to have to see who was in court. You're going to read news articles. These are the kinds of investigations that are required of a defense counsel in post-conviction, and they're simply not happening in these cases. We are going to move on to the discussion portion, but there was just two more slides I wanted to make sure that we covered. This example, Thomas and Yahya, I don't know if one of you want to talk about this example. It's pretty self-explanatory. The lawyer is like, Your Honor, this is such an abuse that my client would even want representation. He should have gotten the death penalty. He should be happy he got life without parole. This is so far afield from what an attorney should ever be saying about their client. But somebody mentioned yesterday at a seminar we were at that the level of loathing that Philadelphia lawyers in post-conviction have for their clients is so shocking. And that is what's really on display in these letters. It's not just you have somebody that's not on your side. You have somebody that truly hates you and is like very hostile to you. And that is just despicable. That is not how it should be. And that's not what people should be relying on when they're fighting for their lives.
Mm-hmm.
Well, I guess I talked about it, so you guys know. And then this last one is just, this one does need a little bit of explanation, Thomas or Yahya, if you guys want to talk about it. This is the level of judicial review that their lawyer has filed a Finley letter.
Yeah,
Okay, so
go ahead, Yahya. Yeah.
okay, so when the lawyer files the Finley letter, again, I mentioned that your lawyer files a Finley letter, and the judge sends you what they call a intent to dismiss petition or letter, and a person generally have 20 days to respond. And most of the people, when you're trying to file it within 20 days, there are some things that occur that many people don't get the whole 20 days. Sometimes if you're incarcerated, anything can affect that. You could get your letter, you could get your mail late. You can get transferred and then never get it. And then you have to fight and explain why you never got that. So all of these different things can happen. The jail could get locked down, and you can't get to the library. And so you can't answer it the time that you need to answer it. But you get a 907 intent to dismiss. And in my instance, I had 8 days and I was able to answer it, right? And so now when you answer it, the judge will send you a letter telling you whether or not they decided to dismiss. And in my instance, the judge sent me a letter that was identical to the Finley filer's no merit letter. All the judge did was copy and paste. Took the Finley filer name off of it and added theirs. My dismissal, my opinion, was almost the Finley letter itself. And so you get that. And then once you get the intent to dismiss, and then dismiss your petition, and now you got to go to the Superior Court, right? And so this is the instance where Thomason's mentioned Commonwealth versus Grant. And so this is a time where a person has to actually, what they call lay their claim. They have to say that PCRA counsel was ineffective for failing to raise trial counsel's ineffectiveness for failing to do X, Y, and Z. And mind you, some of the people still don't have their transcripts and still don't have their discovery. In my instance, I was able to, my Finley filer had filed the no merit letter, and I had to woo her. I wrote her and said, "Oh, you did a great job, and thank you. And all I need is please just send me my documents so I could continue and pursue my freedom and things like this." And miraculously, she sent me my documents. And that was when I was able to put an effective appeal into the Superior Court. But you go to the Superior Court, and if the Superior Court deny you, that's when I mentioned I got a dissent. And if for those who are listening don't understand what a dissent is when one of the judges rule against the rest of the judges. And so the judge say, well, if many of the judges feel like the appeal should be dismissed, this judge right here, the person who dissented, said that I feel like he should get a new trial. But eventually, they dismissed the whole petition, and I eventually go up to the federal court in a 2254, which is a habeas corpus, and like this. And then I filed a certificate of appealability, and that got granted. And that's when I mentioned the case of Martinez versus Ryan, and that eventually got dismissed as well. And so I had to find new evidence after that.
Just wanted to say one thing, because we have the chart. It says the Rule 907 was issued within 1 week. So that means the Finley filer filed their Finley letter, and then within 1 week of receiving that Finley letter, the court said, "Yeah, I have the intention to dismiss this, and you have 20 days to respond to this." So when somebody gets a Finley letter, there actually is an actual letter along with it, and it tells the person, "Hey, look, I'm going to withdraw from your case. I didn't find any merit here. you can go do this on your own now, or you can go hire an attorney. And many times people go, all right, I'm gonna ask my family to try to hire an attorney. I because there's no way I can do this moving forward. And many times an attorney can't get in at that point. Because if you look at it, the court's issuing their notice of intention to dismiss within 1 week. So it's very hard for an attorney to say, yeah, I'll jump in there. I'll jump in the middle of this. So it leaves the person in the ultimate catch-22. They're damned if they do and damned if they don't. And then they have to go and basically become an attorney. And it's really daunting. And I know, Yahya, earlier you spoke of how dejected you were when you received that Finley letter. And when I was working in the law library, that's what I felt every time somebody brought in on a daily basis. People are bringing in, hey, I got this thing the other day. Well, I don't really even know what the heck this is. My attorney, the guy they appointed me, is saying, I don't really know what he's saying. And then I have to explain, he's saying that he wants to get off your case. He doesn't think there's anything here. And people just want to give up. Innocent people, harshly sentenced people, they just go, I can't win here. And maybe in a little bit we can get further into what the realities look like of somebody receiving that Finley letter.
I think that this is a good opportunity to transition to that, actually. And you both have talked about, Yahya and Stephen, you both have talked about the realities of this. You don't have your transcripts, you don't have your record. So would you please walk us through literally how does a petitioner try to preserve their rights under the current system?
Do you want to go, Yahya? You want me to get
All right, go ahead, Steve. Go ahead.
It's, I look at it like, somebody's going to trial, they're given an attorney. That attorney tells them, don't say nothing. So let me do all the talking. And then when you go on direct appeal, you're again giving an attorney. PCRA is sort of such a Frankenstein procedure because you're the person that has to start it off. And there's tight time frames to get everything filed that if you're 1 day late, that's a wrap. It's very hard to get back in after that. And usually the person is tossed into a fight with a professional fighter without any weapons. They don't have their trial transcripts. They don't have their discovery. They don't have anything to plead their case. And they have to essentially become an attorney and file this very complex petition. And then there's also, so you've heard of a law library. I worked there for 15 years. It's not, there's a ton of books in there. There's computers in there. You can look up cases, but it's hard to understand those cases and get this done in a reasonable amount of time. So most people get about 1 hour a week in the law library. And that is to look up your cases. That's to type up your brief. That's to make the copies. That's to do everything. Get advice from the legal clerks. And it's just incredibly difficult to do. And then some people do pull off this really immense task and file this petition that is completely off memory. They're just thinking, they're like, hey, like in the earlier slide we saw, I saw the juror there. He was asleep the whole time. So they're making a claim out of it. And then they're appointing an advocate, and the advocate essentially, laughs at them or demeans them. And what I've really saw is this relationship where I'm doing you a favor. I'll raise what I want to raise here, and if I'll raise anything, and it's just this, really the horrible dynamic. And I don't know, Yahya, if you can.
No, I mean, one of the saddest things about it is that more than 50% of the people are time barred. When I worked in the law library, most of the people who came inside of there, most of the people got time barred. Most of the people, because of not having the transcripts and because of not having the discovery documents and things like this, most of the people sat around and waited for the lawyers that sent them to them, and they never got them. And a lot of people end up time barred.
Yeah.
I just want to say one note about how this data that we have on this screen, how this really reinforces the experiences that Yahya and Stephen are articulating here. In terms of just how alone a petitioner is in this process, because you have the entire legal profession, every entity that is associated with the legal profession is opposed to the petitioner here. You have a Finley filer who has filed an adverse document actively refuting the claims that the petitioner has brought. In 93.5% of cases, the DA didn't file anything because why would they? The claims have already been refuted, right? So the DA has dropped out of the process. And the court is dismissing these in 95% of cases. So, under Finley, the court is supposed to undertake its own independent review. And you have, in some instances, this is happening very quickly, within 1 week in a quarter of cases. In some cases, it was happening the same day that people were filing Finley letters. The court was undertaking its entire independent review in one business day. And so people who are incarcerated are left without an advocate at all. And as you both have said better than I can, under extremely adverse conditions. And you can see the extent to which these are not, the lawyer is not the agent of their client, because look how much disagreement is exemplified by this data. Petitioners are appealing the vast majority of cases. Petitioners are objecting in 60% of cases. In 30% of cases, these are people who who weren't able to afford a lawyer, who have been found to be indigent, who then down the line are having to scrape money together. And, it's coming from the community because prison wages are not paying lawyers' bills. Are scraping the money together to pay for a lawyer who, now that they're being paid, finds in a lot of instances claims that they can present to the court.
And the pro se petitioners are not cut any slack. They're held to the same exact standards as attorneys, and even harder. I mean, you have to make, and Yahya, you know this, you have to make copies of all these petitions that you're getting ready. You have to file 4 copies of the PCRA petition that you're filing. People get paid, what was it? It was 16 cents an hour at one point. That's a lot that means each hour is 1 page because I've written around that. It's expensive. It's a month's worth of wages to send out these petitions, to communicate with your attorney. And again, I've never heard of somebody. Very rare is the have I seen where somebody's appointed an attorney is like, hey, set up a phone call. We're going to talk this out. It's usually 1 letter that you get back, if that, and it says, hey, I've been appointed to represent you. I'm going to look this over. I'll either be filing an amended petition or a no merit letter. There is no back and forth. That's a fiction. That doesn't happen. And Yahya, I'm sure you can attest to that. Let alone somebody coming up to see you and kind of talking it out. Hey, who was the attorney? Who was the juror? Do you remember what the juror looked like that was asleep? Did you tell your attorney? Did they make the court aware? Help me investigate this through. There's none of that. This is more of a going through the motions type thing. I mean, I've read some letters that say, do not call my office. I will not take your call. So don't do it. And that,
I want to interject here because one of the points that I wanted to make sure we talk about is the fact of appointed versus retained counsel. So obviously every letter we saw was we didn't see a single letter from retained counsel. I want to talk about why that is. And so, Yahya, if I can put you on the spot, would you talk a little bit about why that is?
Okay, so well, according to my opinion, if a paid attorney if you have some money to pay an attorney, then they cannot file a Finley letter if you pay them. they cannot then tell you you don't, they cannot then take your money and then turn around and say you have no issues. Right? That doesn't occur. That would never occur.
Why?
Because if you take the money, if the council take the money, then they actually signing on as your advocate. They, or they supposed to be ethical enough to say, I cannot help you. They supposed to read your record, read whatever's going on, and be ethical enough to say, well, this is not something I can take on. Here go your money back.
So this is interesting, Yahya. I'm really glad you said this because I recently watched a training with the courts here in Philadelphia. It was a PCRA training, and there were some judges and some local attorneys. And one of the local attorneys said, you can only file a Finley letter if you're appointed. You can't file a Finley letter if you're retained. It's a violation of the rules of professional conduct. And everyone in the room was like, oh, that's so interesting. And nobody was like, wait, I'm sorry, why are there two rules of professional conduct? One for poor people and one for people with money. Had somebody asked that question, they would have been told that there's just the one rules of professional conduct and it applies equally. And for the same reason that your retained lawyer cannot ethically file a letter against you, harming your case,
right.
So too should an appointed lawyer not file a letter against you harming your case. But it's interesting, interesting is not the word, it's noteworthy that this is the culture here in Philly, right?
Yeah.
Yes, it is. It is. As Thomas mentioned, and again, it affects predominantly Black people and poor people. And so to me, it plays a big part in these wrongful convictions as an extension of it. And like if you can't have an effective appeal, right, you're keeping an innocent person in prison longer than he has to be in there.
It's interesting.
Absolutely.
An attorney that you would hire would do a pre-filing investigation, and they would say, you would have a discussion with your attorney and say, hey, I would like, I think these claims could be raised, dot, 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 dot. And that attorney may investigate those claims and say, hey, I saw these claims should raise. I think we should stay away from these two because they bring up some negative things that we don't want before the court. But a court-appointed counsel will not have that discussion with you and instead tell the court that and the prosecutor and file a public document talking about these negative things. And that really draws the distinction for me. Yeah, and you were talking about innocent, when somebody is innocent filing a PCRA petition, it's difficult for an innocent person to file. To really, you have to look at your transcripts. You have to re-experience the trauma of your trial again. And then when you do that and you document it and you file it and then have an attorney go, I'm not even going to investigate this, but I'm going to talk really bad about it. It is a trauma that is really immense that I've seen play out time and time again.
And the strange thing is, well, I don't know if it's strange, but it is strange. In other ways, many other people who have been wrongfully convicted and freed had Finley filers.
Yeah.
They had Finley filers. They had a Finley filer say that you have no issues. And then had they did the investigation earlier on and found the things that was later found to exonerate them,
Or inadequate counsel, because that is one of the things. I mean, not everybody that didn't file a Finley letter provided effective assistance of counsel. There's plenty of a court. It's kind of and we've spoke about this time and time again. It's kind of a cultural thing. I think Finley is a symptom of something greater, of a lack of, and Thomas, I heard speak about this so profoundly yesterday, but it's a cultural thing where people are not taking being a lawyer is serious, and their oath serious, and their oath as an officer of the court and at service to their client serious.
This is, yeah, Stephen, thank you. This is a really good segue into the Q&A and the first question on the screen. So I'm gonna read this question, which dovetails into exactly what you're talking about. And then I definitely want you to finish your thought, and Thomas and Yahya to chime in. So the question is that since the case Commonwealth versus Bradley, which allows petitioners to raise the ineffectiveness of their post-conviction counsel, the percentage of Finley letters has dropped dramatically. The question is, one, did we look at that at all? And I will answer that because the answer is no, not yet. One of the things we hope to do is a much fuller study of this in Philadelphia, and then we would be able to adequately assess that because I agree it's really significant. And then the second part, which is what dovetails into what Stephen was just saying, this may lead some to believe that PCRA counsel are being more effective, but it doesn't seem to be true. The lawyers are instead just filing really terrible written amended petition rather than Finley letters. Yes, I agree with that. I think we all do. Rather than Finley letters, so that they will represent the defendant on appeal, which then prevents the petitioner from raising their ineffectiveness. PCRA lawyers are so underpaid in Philly that no one who would do a competent job would ever take the appointment. So without more funding, what can possibly be done? So this is a great question. It's really multi-layered. And that's why I interrupted you, Stephen, because I want you to make the point you're making, which is that Finley is not the problem. Finley is a huge manifestation of a crisis in our system. And so I would be grateful if you guys would talk about that and then talk about the funding issue, which is a big part of that crisis here in Philly.
Absolutely. And like I said, I think Finley is just a symptom, and I totally agree with, it was a question, but I totally agree with what was said in the question that there's a problem with the amended petitions even. And I think that you could take a lot of the stuff that was outlined in the Finley report and say, okay, let's take this brick by brick. Let's get some proposals in front of the Rules Committee of how things could be changed. Should an initial PCRA petitioner have to file their own claims, or should they just be able to say, hey, I want to file a PCRA petition? Give me an attorney. I think that's what should happen. I think that we should be challenging Finley in courts. I think that district attorneys should be responding to Finley letters. I mean, I could go on and on, but there are some takeaways from what we were talking about today, and I think that I think we can. I just gave you a couple, but I would like to hear everybody else too.
Now, I've had a conversation one time in the law library some years back, and I remember somebody saying that a Finley counsel should have a colloquy. They should get a colloquy before they accept representation. They should get a colloquy. They should have a colloquy done, like we get colloquy.
I think we need to get some stuff in front of the legislators and have the PCRA is part of the problem, and have that kind of, scrubbed and redone. There's several things. I mean, people just have to care a little bit more. And I'm appreciative of Stoneleigh for giving us this platform, and for Phillips Black for letting us be involved in, writing this report. That's part of it. Having this discussion, because I don't know that this discussion was being had, years ago when the problem was, being created.
Well, and I think that's a super important point you said about the years ago that this problem was being created. I think it's really important that we grasp the scope of this problem. Finley was decided 2 generations ago. Finley was decided in the late 80s. And this is a culture that has been growing and developing and becoming rooted over the course of decades. And there are absolutely some common sense things that we can do that are important and meaningful and will help to increase the amount of process that people have. Things like, like the things that Stephen just listed, but another one that comes to mind is, in other states, it's not the case that, people that incarcerated lay people are articulating their post-conviction claims in the first instance. Like in Arizona, people just file they file a kind of notice saying, I want a post-conviction review, and then they're appointed a lawyer, and then the lawyer articulates the claims in the first instance. So there's not this kind of structural adversariness between client and lawyer from the outset. Things like that, things like just extending that 20-day period, so that people have an actually meaningful opportunity to, if they choose to obtain a lawyer or to, really research and thoughtfully respond to a 907. And there, these are all important things. But, there is a risk that if we only focus on those types of solutions, tinkering with the, machinery of this process, then we risk ignoring the heart of the process, which is that there has been a decades-long relaxation of the ethical standards that defense lawyers approach appointed cases with. Lawyers are not treating these cases with the same level of diligence, with the same level of loyalty, with the same level of lawyering that they do other cases. And that is a cultural problem that is going to take lawyers reinforcing to each other in all types of settings that actually there's not to, being that person in the room. If you're in a room where someone's saying, oh, it would be unethical to file a Finley letter, if you've been retained, pushing back on that. Actually, I don't think that's right. I don't think that's the role of a defense attorney. And I think in the background of all of this is this concern about efficiency. I think that defense lawyers sometimes forget that they do not work for the court. It is not a defense lawyer's job to facilitate the machinery of the court, to facilitate the machinery of incarceration. It is a defense lawyer's job to be an advocate for their client. And we have been living under this Finley regime that allows lawyers to go so far from being advocates for their client to being adversaries to their client in order to grease the wheels of getting post-conviction petitions dismissed, that we have forgotten the core aspects of our role in the system, which is absolutely not to facilitate it rolling along smoothly. It's to gum it up. It's to challenge it. It's to say, this isn't ethical. This isn't right. My client's not being afforded their rights. And that's incumbent on defense lawyers to do. And it's going to be hard to fix this culture. And I think it's important that we acknowledge the depth of the rot.
I totally agree, and really well said, Thomas. I think, the question that was posed was like, can this be fixed when the fee caps are so low? And just so everybody on the call knows, in Philadelphia, post-conviction counsel is paid $6,000 total. That's for the initial petition, that's for the hearing, that's for the appeal, that's for everything. That's totally untenable. And the fee has to come up, full stop. And also the fee is not the source of the problem. The fee reinforces, right? It incentivizes bad lawyering, but it also affirms bad lawyering. It says to the lawyers, no, your job is just to investigate these 3 issues that your client could raise with no transcript and no record and no, notes from the trial. Your job is to just read those and argue against them. That's what's reinforced this here. And I think that everybody that just spoke is right. This is a culture problem. Another question that we got was, where do we think the biggest accountability gap sits? Judicial oversight, defender culture, lack of resources, appellate structure. I want to say, because the word defender was used, the Defender Association and Philadelphia only takes 1 out of 5 homicide cases. The other 4 out of 5 people who are on trial for homicide are represented by private appointed counsel. So I want to be careful using the word defender, even though that may not have been used to talk about public defenders. This is really about the privately appointed bar here and the way that's structured. I think one big change would be to fully fund the Philadelphia defender, to do post-conviction. They do no post-conviction, and to do 100%, well, they can't do 100% because of conflicts, but to do the majority of homicide trials. What do you guys think?
I totally agree. And I know that none of the Finley letters that we reviewed were issued by the Defenders Association. They don't issue Anders briefs, so that is a great start. They lawyer up and they do their thing. Yeah, I just wanted to put that out there that they're exquisite, great attorneys.
And just to echo that, the reason that that would be such a powerful solution is because the Defender Association has a healthy ethos of what it means to be a defense lawyer.
Mm-hmm.
And that's why they're not filing Anders briefs or filing things like this that we're seeing in the Finley context. Because they have a culture that is meaningfully distinct from the culture of unethical lawyering that Finley Letters is representing.
And it's really all the above. I know yesterday we had a question in one of the seminars of like, give me a silver bullet, and there is none. And that's the problem, that we try to fix stuff with a silver bullet. Really, we have to put in the hard work, and it's really brick by brick. So I think it's all the above. Yeah, there should be judicial oversight. They should never issue a 907 order within 1 week of receiving a Finley letter, that they've reviewed the Finley letter and the record and said, yeah, this is great. That should never be a thing. So yeah, they have to be held accountable too. We've already been through, the bar, the culture of the bar in general. And appellate oversight, yeah, you should never be able to file a Finley letter in the Superior Court. That goes against the whole procedure of Finley itself, which is horrible. And what was the other kind of pillar we wanted to knock down or enhance?
All of them. Yeah.
No, I totally agree. I feel like the onus is partially on everyone. I do believe I do believe people should be able to have their transcripts faster. If the lawyering is not, if this is going to happen to them down the line, give them their things so they can really be pro se then, right? I do believe that it's on oversight, right? It's a lot. I think that the system is the system, and it's all different parts of the system coming together as one. So I don't think it entirely happens in a vacuum, right? It's just everybody plays a part, because the same Finley fowler is then a paid attorney working to help the fight somebody to get free, right? And so, in that instance, then they're not acting as an advocate for somebody. I mean, an adversary for somebody, right? So, I just think we as I mentioned yesterday, we got to do better. I mean, it's the term when you know better, you do better. I'm not really seeing it.
Yeah.
We just have a couple more minutes, and I just you guys have mentioned some things that can be done, and Stephen, you've talked about rule changes, which I think is an awesome idea. Yeah, I totally agree. People should be immediately provided their transcripts and their record. To saddle them with a lawyer that's not going to do their job and deprive them of their record, let's really think about what that means. I also want to give a shout out to the participatory defense hubs, who I think do an awesome job of helping people understand the legal system. Our legal system is designed to intentionally exclude people so that you go to trial and you don't understand what's happening. There's Latin being batted around, for crying out loud. And so, to then be saddled with a lawyer who's working against you is just mind blowing. I think, if there's one of the other questions that we have is about people navigating post-conviction systems who do not even really understand what their attorneys are filing, and there is no requirement that their attorneys even talk to them. And so in our like last minute, if you guys have other ideas about what can be done about that, how can that be addressed?
Well, I'll speak to that quickly. I think part of what Yahya and I really wanted to do, in addition to the report, we also wrote this law review article together. And part of what we wanted to do was to draft a document that would be instructive to people who are incarcerated, who are going through this process, and their loved ones, and to try to, the feelings of betrayal or the feelings of something not being right. I mean, I think that because unfortunately the reality of the post-conviction system in Pennsylvania puts the onus on people who are on people who are lay people who are incarcerated to vindicate their own rights, which is unfair, but it is a reality. We wanted to make those a tool for people so that their experience could be amplified and they could say to a court, I told my lawyer this thing, and then they turned around and told the court about that, and that doesn't feel right. Now there's a statistic to point to, and that to help grab the eye of the judge, to educate the judge that this is something that's happening in other cases. This is a real problem. And so I would encourage people to review those kind of as view it as kind of a resource, as a way to help articulate in this really tough position that the law puts people in that's unfair. We're hoping that it's a resource for people.
I know we've been able to do something with Phyllis Black if actually going into the prisons and doing seminars, and I think that has been really helpful. And Thomas, you've been kind of, the thrust of that, and telling people, here's some of the problems we've seen with here's how not to get Finleyed. I think that was the name of one of our seminars, how not to get Finleyed. And I think that's really important. And we kind of opened ourselves up to receiving a bunch of emails from family members. We're trying to do our thing there. And also, I think I would love to see the Finley report, kind of this discussion to be taken into law schools and be taught to law students, because they're the next generation, and to have kind of, the idea of filing a Finley letter very abhorrent, like that it's not something you would want to do. Again, changing the culture.
All right. I think we are at time. We haven't even gone over, which is a first, I'm pretty sure. I can't hear you, Mark. I don't know if others can.
No.
I'll take this moment to say one thing I should have said, which is that Mark's going to send out a follow-up email after this to everybody who registered. It's going to have a link to the report and to the article and the citation for the articles on our website. And I think he's going to send a link for the recording of this as well.
That's correct. And Jenny, can you hear me now?
I can, yeah.
Excellent. Yeah. So as Jenny mentioned, there will be a post-event email after this that will include a link to the report, a link to the recording. I know we're running up on time here, so I'll go ahead and close this out, but please feel free to follow up if you have any additional questions or our audience about today or what comes next. So on behalf of the Stoneleigh Foundation, including our executive director, Ronnie Bloom, and our board of directors, I'd really like to thank you all, our outstanding speakers, Jennifer Merrigan, Stephen Lazar, Thomas Moore, or Yahya Moore, my apologies, and Thomas Roberts for organizing such an informative and compelling dialogue. Stoneleigh, of course, is a partner in this work, really honored to support your work, and really appreciate you all providing us with some really clear and actionable insights from today's discussion. In particular, for me personally, I think about how this has really underscored how truly vital it is for attorneys to follow all of their duties in representing their clients, and the impact that cutting corners or acting in the court's interest or their own interests can have on their clients' lives. So that's what I'll be taking away from today's discussion. As for next steps, as mentioned, we will send around a post-event email. We will also include all of the questions, copy of all of the questions submitted today for our speakers. So if there's one we weren't able to get to, they may be able to address it after the fact. And in addition, we'll be hosting a number of upcoming webinars, so you can check all of those out on our website, stoneleigfoundation.org/events. And once again, to our audience, really, truly, thank you all for taking the time to be here today. We hope you enjoyed it as much as we did. So take care.
Thank you.
Thank you.
Thank you.